My dear listener, there is a new wave of expressing your views and voices in downloadable format that you can share with your friends across the globe. What am I talking about? Have you heard about Anchor.fm? Now, Anchor is the simplest way and the easiest way of expressing or sharing your podcast. Now, remember, it has creation tools that allows you to record and edit your podcast right from your phone or computer. Amazing way. Anchor distributes your podcast for you from Spotify to Apple Podcast to Google Podcast to different other platforms for free. You don't need to pay. And interestingly, you can monetize your podcast with no minimum listenership. You don't need to have a particular number of listeners for you to monetize. Therefore, download the free Anchor app or go to anchor.fm to get started. You will not regret it. So on this particular segment, we want to know more about gratuity. Does the name itself ring a bell in your ear? Take your employment contract and go through it again. Does it have this clause? Were you duped? Well, first of all, let us understand the term gratuity. It is a lump sum amount that an employer pays an employee on contract when he retires or resigns from the organization. Generally, gratuity is payable upon successful completion of the agreed contract term. In alternative, an employee qualifies for gratuity payment after a specified period of employment, usually 5 years and above of service with the employer. An employee does not contribute any portion of his salary towards this amount. The rationale for gratuity is to encourage employees to offer longer service to the employer and to ease the termination of contract of employment by offering the sum of gratuity as consolation. Gratuity is not provided for as a minimum condition of employment, but it has developed as a good practice in employment, and employees have come to expect it from their employers. So gratuity is usually paid in the following circumstances. Very, very important. When the employee retires, when an employee resigns, in event of death of the employee, in event of disablement, that might be because of accident or illness. The gratuity payable depends on the terms of the contract of service. The prevalent practice is that the employer pays the employee a month's basic salary for every year of service. Remember that. The prevalent practice is that the employer pays the employee a month's basic salary for every year of service. For instance, if your monthly salary is $500 US, coming up to almost 50,000, and 50,000 Kenya shillings, and you have worked in company X for 10 years, then you are entitled for a total sum of 50,000 times 10 years, which is around 500,000 Kenya shillings or $5,000. However, there is no reason why the employer and the employee cannot agree on alternative amounts. Maybe amount that is beneficial to all of you. In essence, gratuity should be a term of the contract of employment. It is not payable if the employee is summarily dismissed, as the employee is usually in fundamental of the terms of employment. In such an instance, the employee cannot insist on enforcing the term of employment against the employer, having failed to keep his part of the bargaining. So if you've been sacked, then it becomes a challenge. You cannot ask for this. But that does not prevent the employee from staking a claim in the industrial court, alleging unfair dismissal and citing the need to avoid paying the gratuity as why the employer dismissed him or her. Now, with regard to resignation, the contract of employment should state the minimum period that the employee should have served to be entitled to gratuity. That is why we post a question. Is your contract having that? Thus, if an employee resigns after 5 years, he is eligible for gratuity or for that particular period that your contract has stated. The law does not anticipate that one will work for a single employer all his life. If the employee resigns citing ill health, depending on the stipulations of the contract, he may or may not be eligible for gratuity. The contract of employment may put a limit on the period when the employer or when the employee must have served to be eligible for gratuity. However, if the ill health is as a result of work injury acquired while with the employee may be entitled to claim gratuity, at least for the period already served. So if you've got injured in the line of duty and you are just there for like 3 years and the time that you guys had talked about was 5 years, then you can ask for the same, the number of years that you have worked, so for the 3 years. In event of death of the employee, the gratuity is to be paid to the nominee of the employee or the personal representative. That is why it is important always to give the details of your next of kin whenever you go to a particular place of work. Just like in resignation, the contract of employment may stipulate the period that the employee must have served to be eligible for gratuity. When an employee is laid off due to redundancy reasons, and redundancy is the state of being no longer in employment because there is no more work available or you're no longer useful to the organization, then depending on the stipulations of the contract of employment, the employee should be entitled again to gratuity. That is at least for the years worked, as he can argue that, but for the layoff, he was willing to work until he was entitled to gratuity. But usually gratuity here is part of the negotiated golden handshake for the layoff. So you find that you're told that you're going to pay you the damages, the amount, total sum of this particular amount, but you have to be laid off. So to decide whether termination was just and fair, the industrial court is required to consider the procedure adopted by the employer in the termination. And here the conduct and the capability of the worker up to the date of termination, the extent of compliance by the employer of statutory requirements, the previous practice of the employer in dealing with the circumstances that led to the termination, and the existence of any previous warning letters issued to the worker will play a big role at the industrial court. A worker may lodge a complaint with the labor officer within 3 months from the date of unfair termination. Where the labor officer finds the dismissal or termination unfair, he or she may recommend that the employer reinstates the worker and treat him or her as if the employment was never terminated, or re-engage the employer in work comparable to the one prior to his or her dismissal at the same wage, nothing less. So, see why it is important? Now, if the employer is undergoing losses or goes into receivership, those are not reasons enough to disentitle the employee to gratuity. Losses do not afford or accompany the defense to breach a contract, and gratuity is clearly a matter of contract of employment. If the company is under receivership, then the affected employees will be entitled to claim gratuity against the receiver of the employer as a contractual debt. So it is very, very important to understand the gratuity issue in your employment, and go through your contract, check it out and see, try to look at it, confirm, or you can ask your boss if this particular clause is within the contract. If it is there, then you have your decision to make.